I'm gonna go do a little update for the case. We were arrested July 3rd, 2021, for unlicensed possession of a firearm, possession of ammunition without FID card, improper storage of a firearm where a minor had access, uh, improper storage of a firearm, possession of a loaded firearm without a federal ID card or license, whatever the Massachusetts statute is, conspiracy, the wearing of body armor during the commission of a felony, and furnishing a false name after arrest. We were arrested, 11 of us were arrested July 3rd, 2021 for those charges. The Commonwealth of Massachusetts, via the district attorney or assistant district attorney, Graham Van Epps, is charging us with joint venture, which means if one of us did it, we all did it. Trooper Ryan Casey, May 10th, 2022, during a motion to suppress hearing, stated out of his own mouth that he was investigating us. And I made this post on Instagram with I have the transcripts here, with the underline of him sworn under oath saying that he was investigating us July 3rd, 2021, within 3 minutes and 10 seconds of him seeing us. He never read us our Miranda rights, ever. Sergeant Matthew or Matt McDevitt, I'm not sure what his first name is, said on his own police report that he did not read us our Miranda rights because he didn't want us to stop talking. So our Fourth Amendment right to due process has already been violated. For the Moors that have for the Moors that are represented by counsel, all of the defense attorneys have been telling the Moors that we have a strong Fourth Amendment argument because our Fourth Amendment right to due process has been violated. Because, according to the Massachusetts Superior Court, that knowledge of a firearm alone under the Fourth Amendment does not raise reasonable suspicion. May 10, 2022, during the motion to suppress, Trooper Ryan Casey specified that since he observed what he believed to be firearms, he launched his investigation of us 11 Moors. And then, obviously, with the new Supreme Court case, the Bruin decision, which I'll go into a little bit more later, that and the Massachusetts case with Guardado, which the standby counsel Daniel Thompson argued that case, they already talked about how mere possession of a firearm alone does not raise reasonable suspicion. So multiple times the Superior Court of Massachusetts and several courts of Massachusetts have already specified that mere possession and knowledge of a firearm alone does not meet the standard of reasonable suspicion. So there would have to be some type of additional behavior, like the individual is pointing it at someone, the individual is aggressive, or the individual is running, in a frantic manner, things like that. So behavior that would indicate a crime, not just the possession of the thing alone, which that is what Trooper Ryan Casey said under oath is what gave him reasonable suspicion. Because according to the constitutional law, which this is reaffirmed by the United States Supreme Court, there are only 3 types of police interaction. One is consensual, where the person has the right to leave. The other is a Terry stop, which requires reasonable suspicion. And the third, is an arrest, which requires probable cause. So mere possession of a firearm alone does not meet the second or third standard as far as interaction with police. Trooper Ryan Casey specified that he was conducting a community caretaking encounter, for lack of a better words, which are completely separate from the investigation and acquisition of evidence leading up to criminal indictment. So under the pretext or pretense of community caretaking, he was not able to turn it into an investigation absent any exigent circumstances, which there were none. Once he realized we didn't need help, we were supposed to be free to go. Throughout this case, there has been I forgot what it's called. What was that order to not say anything? What's it called? I forgot what it's called off the top. I don't know who it is. I don't know who made the statement. I still haven't received the paperwork from Daniel Thompson yet based on my own choice. I don't want to know until trial so that way I can see. So that way, if this person's identity gets exposed, it's not me who did it because I haven't seen the paperwork. But anyway, we all of us except for the individual, so do your own research, have an order to not say anything about who said what. I do know that Will was threatened by the police. He was offered a deal. He denied it when Rashad Bey got his charges dismissed in Massachusetts, which he was being charged with the same thing: possession of a large capacity weapon, possession of a large capacity magazine, improper storage of a firearm, possession of a firearm without a license. And Rashad Bey has talked about this publicly. The prosecutor offered him 5 years or something like that. He said, no, let's take it to trial, and they dismissed it. So when Will heard about that, the day he was supposed to accept a deal, which he was violating his terms of bail by even communicating to the specific Moore that he was talking to, because he wasn't supposed to talk to any of us. But he was violating his conditions of bail by telling us what was going on. So he was offered the deal. The day he went to court to accept the deal, he seen the paperwork from Rashad saying that the case was dismissed. So he said no. Then they sent the FBI to talk to him and his mother, and threatened him. So he took a deal and turned himself in. Now, obviously, for anyone who knows the law, anytime you take a plea deal, the judge asks you on the record, do you understand that you're waiving your right to a trial? And you have to say yes. Then the judge will ask you, do you understand that you're waiving your right to have the state prove beyond a reasonable doubt that you even did anything? And, they won't say that you even did anything. They'll say that as an example. Do you understand by pleading guilty you're waiving your right to have the prosecutor or the state prove that you committed these crimes, and then they'll read off the crimes. And you have to say yes. So any Moore that has taken a deal, the prosecutor still hasn't proven anything. They just took a deal. Right? Quinn Kabir L was released a little bit before me. He was listening to Lamont Maurice Bay, I think his title is, right? And who was part of the consulate, who told him not to show up. So a warrant was issued for Quinn. He's still in jail right now. Lamont's not there to help. Lamont's also in jail, and the consular stuff that he was talking about is not working. So both him and Quinn are now in jail because he was listening to Lamont, which I warned him against. Specifically because this is a public case, and Moors will use the notoriety of this case to boost themselves. So as an example, when you look at Lamont's website, you'll see it's called like Rise of the Moors. It's supposed to be about Quinn, but Rise of the Moors keeps being dropped because he was riding the wave that the media was portraying. The militia does not belong to Rise of the Moors. The militia was part of, it was a subcommittee within the Moorish Constitutional Convention with the specific purpose of establishing an interim special committee. I said that wrong. It was the interim special committee with the specific purposes of establishing a Moorish Constitutional Convention and taking all action to see that comes to fruition. It was a body politic of over 200 Moorish Americans from all around the world. So it wasn't a Rise of the Moors thing. The media portrayed it as that because that's their job, is to demonize people that do this. So them not realizing that they're falling into the trap of divide and conquer, they fell into the trap of divide and conquer, and that's exactly what they did. So Will took a deal. Quinn is in jail. The last hearing we had was April 24th. Tarif tried to take a deal, but they didn't let him that day. He said this publicly, so it's on public record. It's not like it's hidden information. Because, and let me see if I can show you the messages that he has sent me. His attorney is not answering any messages, so he's like, and if you were there that court date, you'll see that his attorney didn't even know that was the court date, so he wasn't even there. He had to be contacted by another attorney, and he showed up via Zoom. Let me see if I can find some of the messages from Tarif. Since we are talking about everything. Here's one of them. It doesn't really show the full thing. He has it on his phone, but just to show you that this is from Tarif first. Well, That's from Tarif. And you don't see the full thing, but just so you know, uh, when we were on the way to court, he was telling us that this decision was made under threat, duress, and coercion. Uh, I spoke to him directly. And there's other mores to witness to that statement, so it's not just me making it up. But that's the message from Tarif to his uh, standby counsel or full counsel Gil, and you'll see multiple times where he messaged him and he never responded. And there's even more so to that Tarif showed me on his phone. Not Aban. Conald and Omar's attorneys. Well, let me back up. I filed a motion to join the cases while I was in jail. Judge James Boudreau denied it. No, he didn't deny it. He said that he'll leave it up to the trial attorney. Subsequently, the prosecutor Van Epps filed a motion to join the cases. It was the same time that we had a hearing to continue the cases because he has other trials going on. So the date was pushed back from its original date, and then scheduled for May 22nd and around October, I believe. The Commonwealth's motion to join the cases was obviously granted because the courts are only granting their motions. During that time, it was myself, Jamil, Aban, Lucha, Conald, and Omar's cases that were all on the prosecutor's motion to join our cases. That motion was granted. This last hearing, Conald and Omar's attorneys were arguing that the order joining their clients' cases with ours wasn't clear, which they're just lying. They're supposed to be joined with us, but their trial date got pushed back to August 7th with Quinn and Aban, right? I think so. Aban argued that he wanted to be tried with me and Lucha, or Lucha and I. During the prosecutor's motion to continue, I agreed with the continuance because, and this was before Justice Hagan, because I had argued my Bruin motion, which was 60 pages, before him, like I can't remember when, but it was before that, and it was pending before him. So I agreed with the motion to continue the case, to push the court date back because, and this is on the transcript, which I have, because I intended to appeal his decision if it was not favorable to me. He made a decision November 9th, 2022. I didn't get notice of that decision until February 8th, 2023, 3 months later. I only have 30 days to appeal, so I didn't get it in time. So April 24th, I asked Judge Pierce, who found me dangerous, then gave me bail because Van Epps had the same argument that he made during my dangerousness hearing to try to keep me in jail longer. And then Judge Pierce said, all you did was provide the same argument that you did at the initial dangerousness hearing. You're not providing anything new, so we're going to let him go on $8,000 bail. Van Epps tried to use this ticket that I got for going to the hole with Lucha, saying that we tried to incite a riot. That ticket was dismissed. I have the record of it. It was dismissed. And then they sent me to another unit, but then an individual that worked for the jail told us that they just wanted to separate us because all the Asiatics were coming to my cell asking me for about the Constitution, and they said that we were recruiting people into our organization, which we were not. So I asked the judge if I needed a license to file an appeal, and he said, no, I don't need permission to file an appeal because it's a constitutional right. He then said that I have to file a motion before the trial judge when the hearing will be scheduled, which is supposed to be scheduled 7 days before trial. I can't remember exactly when that day is, but I submitted 2 other motions. One I titled the Sovereign Citizen motion because James Boudreau and Trooper Ryan Casey and the prosecutor keep calling me a sovereign citizen, and the judge made a decision that I am a sovereign citizen, even though I'm supposed to be innocent until proven guilty, but they're labeling me, they're finding me guilty of being something without any proof. So I filed a motion to prevent them from calling me that at trial because that affects my status as innocent until proven guilty. In order to be a sovereign citizen, there has to be evidence supporting that by the fact finder, and then the fact finders have to agree that I'm a sovereign citizen. And since I'm going to trial, the fact finders is going to be the jury, not anyone else. So the jurist will have to decide if I'm a sovereign citizen or not, just like they have to decide if I'm guilty or not. But the courts have already found me guilty of being a sovereign citizen. So I put in a motion there. I plan on asking the judge if I can subpoena Justice James Boudreaux, because he called me one, the prosecutor himself, because he's called me one out of his own mouth, and Trooper Ryan Casey, so I can cross-examine them on the stand during this hearing for the sovereign citizen motion. The other one is asking the court to give full faith and credit to specific documents and make a finding on those documents because they may have a impact on my standing in this case. All this is on the public record already. The court's address is 200 Trade Center, 200 Trade Center, Woburn, Massachusetts, if you need the address. What am I missing?
The date. Did we give the date?
May 22nd, 2023 is the trial date.
The first trial. Second trial is August.
Yeah, the second trial is August
7th.
So the schedule is myself, Tarif, and Lucha are scheduled for May 22nd, which is in a few days. Again, the reason why Conald and Omar's attorney decided to sever the cases is because they're claiming that they have a different theory of defense. I'm not really sure what their theory is, but they're trying to say that I'm saying we're guilty, which I'm not, because they asked me how do I plead, and I said innocent, which clearly means not guilty. And then they said that they're going to use the Second Amendment, which they said out of their own mouths, they're going to file a Second Amendment motion, which all of my arguments have been based on the Second Amendment. And I'll show you right here. This is the United States Supreme Court case. Can you turn the camera a little bit? It says right here, Supreme Court, you see that, right? SupremeCourt.gov. So this is not my sovereign citizen belief. This is from the SupremeCourt.gov. .gov means government. Supreme Court of the United States. And this is called the Bruin decision, right? What I'm claiming is that the conduct that they're charging me with, right? And we'll read conduct. This is Black's Law Dictionary, 4th edition. Mine is ripped. 4th edition. It's also signed by the retired Chief Justice of Rhode Island. If I can find where he signed it. I can't remember where he signed it. The page probably fell out.
I think it's in one of those front pages. One of those front pages that you have separate.
Signed by Chief Justice Frank Williams. And if you look him up, you'll see he's like a Abraham Lincoln historian. So he should know about the case where he defended the Moors. But anyway, he signed my Black's Law Dictionary. We had a meeting in his office. It was myself, my wife, and Moreno Bay. We spoke to him. Anyway, conduct says, this is Black's Law Dictionary, 4th edition. You can find this at 250 Benefit Street, the Supreme and Superior Court that Justice Frank J. Williams, I think he either established it or like redid it. Conduct, personal behavior, mode of action, any positive or negative act, right? So what I'm saying is, in my defense, is that the conduct that they're charging me with is protected by the Second Amendment. I'm not saying that I did anything. What I'm saying is what you're charging me with is protected by the Second Amendment, which means you can't charge me with it, right? That's considered an affirmative defense. For some reason, Conald and Omar's attorneys aren't hearing that. They're hearing that. They even said out of their own mouth that I'm throwing their clients under the bus. I never pointed at more and said he did X, Y, and Z. That's crazy, right? And proof of that is in the United States Supreme Court case, the Bruin decision, where this is where it says it. Look, I'm going to do Control F, which means Control Find. Can you point here so that way they can see? And let me just go back to the top because something was already there, so it went down. All right, so this is the same. I didn't change anything. I press Control F, this pops up. And I'll put plain text. Under Heller, which is another Supreme Court case, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct And to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. So they're charging me with possession of a firearm. The plain text of the Second Amendment protects the possession of firearms. They're charging me with the possession of ammunition without an ID, FID card or whatever. The Second Amendment's plain text, as well as copious federal court decisions, protect ammunition as arms, or falling within the definition of arms within the plain text of the Second Amendment. They're charging me with the wearing of body armor during the commission of a felony. The felony that they're claiming that I was committing was the possession of the firearm. So they're saying that mere possession of a firearm makes you a felon, right? So it's not like I was committing murder while wearing body armor. That would be the wearing of body armor during the commission of a felony. What they did was they took the plain text of the Second Amendment, the conduct of the Second Amendment, turned it into a felony, and then said if you do that while also being dressed like a militia member, you're committing a felony. And now you're wearing body armor in the commission of a felony. So what I'm arguing is that the conduct that they're charging me with is protected by the plain text of the Second Amendment, right? I'll also do this right here. Same thing. I think it's, yeah, there it is. The constitutional right to bear arms in public, that's what they're charging me with, for self-defense is not a second-class right subject to entirely different body of rules than the other Bill of Rights guarantees. So now, name one other Bill of Rights where you need a license for it. Name one, and then you can't. Likewise, when we go back to the plain text, you don't have to show this. When we go back to the plain text of the Second Amendment, as soon as it pops up. All right, we'll read it again. We hold that when the Second Amendment's plain text covers an individual conduct, the constitutional presumption protects that conduct. So this is actually a different paragraph, but it does mention the two-part approach, which I already talked about multiple times. The strict scrutiny, intermediate scrutiny, which is the standard that they were using to justify all these unconstitutional statutes, which the Bruin decision struck down. The Supreme Court also stated in Caetano in 2016 that the Massachusetts lower court's interpretation of Heller is dangerous. So this is not a, oh look, this just appeared before us. This is an ongoing thing. Anyway, the Supreme Court said we decline to adopt that two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Period. So the conduct that they're charging me with falls within the plain text of the Second Amendment, which means this should be thrown out. But anyway, it talks about to justify its regulation, the government must not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulations. And they actually reference the Young versus Hawaii case that I referenced July 3rd, 2021, where they went over extensively the history of the Second Amendment. And if you want to show this real fast. Right, so this is cdn.ca9.uscourts.gov. This is Young versus Hawaii, and after I read this, I'll go back up and show you. Right, the plain textual understanding, so again, plain text of bear arms finds unequivocal support in the most prominent, widely circulated legal treatises from throughout the founding era. Right. The right to armed self-defense is the first law of nature, and that the right of the people to keep and bear arms is the true palladium of liberty. Let me see, where does it start at? Following Heller's historical imperative, The inquiry turns to 19th century judicial interpretations of the right to bear arms, whether as part of the Second Amendment or I know how to say this word. Hold on. It's just looking at it is weird. Analogous, there we go, state constitutional provisions, right? Many of the same 19th century cases marshaled in Heller to prove that the Second Amendment secures an individual right to self-defense reveal just as persuasively that the amendment encompasses a right to carry a firearm openly outside the home. So again, Trooper Ryan Casey believed that we were in possession of what he appeared to be firearms publicly outside of our home. The plain text of the Second Amendment protects that. Which means what? It's not sufficient under the Fourth Amendment to give rise to a probable cause or reasonable suspicion that we were illegally carrying that gun, had committed a crime, were about to commit a crime, or just finished committing a crime. Right? The first of these is Bliss versus Commonwealth, which was cited in Heller, which is the United States Supreme Court. A decision especially significant both because it is nearest in time to the founding era and because the state court assumed, just as Heller does, that the constitutional provision at issue codified a pre-existing right. Right? The right of the citizen to bear arms in defense of themselves and the state shall not be questioned. Tennessee's highest court offered its own similar interpretation of the right to bear arms in Simpson versus State. Notice how they're citing different case law from all of the different states, not just one, because it's res judicata, right? Thereafter, hold on, show this please. Simpson was convicted of disturbing the peace by appearing armed in public. Isn't that exactly what they're charging us with? Because they say that the licensing scheme is part of a regulatory scheme for public safety. That's literally what they say, right? So they're saying I'm disturbing the peace by bearing arms publicly without a license. He faulted the indictment for failing to require clear proof of actual violence. The High Court agreed. First, the court cast doubt on the state's argument that English law would have allowed conviction without proof of actual fighting of two or more persons, right? So they're trying to say, oh no, it's still a crime, and it's not, right? No such prohibition could survive the state's constitutional grant of an express power secured to all free citizens of the state to keep and bear arms for their defense without any qualification whatever as to their kind or nature. And then it continued. Then it says in 1840, the Alabama Supreme Court offered a similar interpretation of its own state's constitution in State versus Reed, construing that the Alabama right to bear arms in defense of self and the state. The court declared that an Alabaman must be permitted some means of carrying a weapon in public for self-defense. The court ultimately upheld a restriction on the evil practices of carrying weapons secretly, citing the legislature's power to enact laws in regard to the manner in which arms shall be borne, as may be dictated by the safety of the people and the advancement of public morals. But the court made clear where the legislative power ran dry. This is from the court. We do not desire to be understood as maintaining that in regulating the manner of bearing arms, the authority of the legislator has no other limit than its own discretion. A statute which, under the pretense of regulating, amounts to a destruction of the right, or which requires arms to be borne so as to render them wholly useless for the purpose of defense, would be clearly unconstitutional. So that means improper storage of a firearm, that being a charge is unconstitutional because it renders the firearm useless. What's the point of having it? Right? Likewise, one more time. Oh, hold on, my bad. I forgot to go up to show the case so you can see for yourself. Right? Young versus Hawaii. Young versus Hawaii. And you'll see in the New York Supreme Court case, Control search Hawaii. Young versus Hawaii. which is exactly the same paperwork I gave to Trooper Ryan Casey on body cam footage, July 3rd, 2021, which the United States Supreme Court case referenced, dealing with the plain text and history of the Second Amendment, because Young versus Hawaii goes extensively into the plain text and history of the Second Amendment when they found that Hawaii's statute violated the Constitution, which the Bruin decision found Massachusetts, and we'll look up Massachusetts, where they said that their firearms statutes are unconstitutional as well. Oh, look, they even put Caetano versus Massachusetts, because when you read this case, you'll see where the Supreme Court said Massachusetts' interpretation of Heller is dangerous to our fundamental rights and liberties. Let's see where they go over. It's probably up here. Oh, that's the last one. All right. They include Massachusetts as having similar statutes. So the day before this decision was made, my motion before Judge Boudreaux was arguing that the statute that they're charging me with was unconstitutional. He said, no, they're not. The next day, the Supreme Court of the United States of America said Massachusetts statute's unconstitutional. The next day, right? So, and like I said, this is the last time, right? This is from the Court of Appeals of Massachusetts, right? They said, that since this is what they said: there is no right under the Declaration of the Rights of Massachusetts Constitution for a private citizen to keep and bear arms, and thus to require that a citizen have a license to do so is not unconstitutional. Now let me show you the source. Let me show you the source. This is the source. Right?
Read it again.
Hold on. This is the judge. Right? This is the appellate court of Massachusetts. So where's this case from? It's from Massachusetts. Massachusetts, right? They said, this is what they said. They said that since there is no right under the Constitution for a private citizen to keep and bear arms, to require that a private citizen have a license to do so is not unconstitutional. So they're saying, since there is no constitutional right, there's no individual constitutional right for a private citizen to keep and bear arms, that means to license it is not unconstitutional. Now let me show you the reference. Let me show you the date. 1983. 2008, the United States Supreme Court said in Heller that there has always been an individual right to keep and bear arms, which means what?
That was wrong.
Which means not only was it wrong, that means to license it is unconstitutional. And that's the United States Court of Appeals. So by every United States law and every Massachusetts constitutional law, what they're doing is wrong, but they're doing it anyway. Why? Because you aren't going to do anything about it. You aren't going to say anything about it. You're not going to show up to court. You're not going to even write letters to the Attorney General or to the Governor of Massachusetts saying, hey, what you're doing is a blatant... You're not even going to send an amicus. All these Moors that talk about they know all this law stuff, you're not going to send an amicus brief to the governor. You're not going to send an amicus brief to the judge. You're not going to send any type of support whatsoever saying this is wrong, and here's all the laws as to why what you're doing is wrong. So it's either you're going to show up or you're not. Whatever you do is up to you. I know what I stand for. I know what I'm going to do. I fear Allah more than I fear these people threatening me with 88 years of prison time, even though when I was in jail in Billerica, there was a man who committed armed robbery of 11 stores in 1 month, committed Grand Theft Auto, and a bunch of other stuff, and they offered him a deal of 5.5 in a day when he's already sat for 2.5 years, so he's already out for armed robbery, pointing guns at human beings. That is conduct not protected by the Second Amendment.
Right, because
and they're not threatening him with 88 years.
You asked one of the officers if you ever threatened them.
I asked Trooper Ryan Casey under oath on the stand during my motion to suppress, May 10th, 2022, if I ever pointed anything at him, if I ever threatened him in any way. He said, no. I'll show you. So there was actually no conduct of mine that indicated any criminal behavior whatsoever. I have it separate with the stuff that I'm bringing for trial. That's why all my stuff is all over the place. Make sure I got the date right. Yeah, May 10, 2022. And I'll read some other stuff probably Sunday. But this is May 10, 2022. That's the docket, all the good stuff. Move this up. Starts on my cross-examination starts on page 44. And then Trooper Ryan Casey said that he would say that the Massachusetts State Police is a paramilitary organization. So when the Constitution says that there shall be no standing army during any time of war or time of peace, they're already violating that by the Massachusetts State Police being a paramilitary organization. So we're under military occupation by the police.
Do you want to take this so that way you can kind of...
No.
Okay.
Here's proof that Trooper Ryan Casey was sworn in under oath. So these are statements that he's making under oath. That's on page 8 of the transcript, if you get it, if you're interested in getting it. And I have specific things underlined of what he said. I just have to find it. I asked him, there was a second officer that showed up, and Trooper Casey told him what was going on, and Trooper Casey said, "So what do you think?" And the guy responded, and this is all documented. He went, "Psh, psh." And then Trooper Casey said, "Yeah?" And he said, "Psh," which means let him go. I asked him about that in court. He said he doesn't know what this means, even though everyone knows what it means. And then I asked him, hold on, because it's funny, because then he says exactly what it means, right? I said, "Can you please state who the second Wakefield," I believe he was Wakefield, the second Wakefield officer was who responded? He said it was Sergeant Burnham. At a certain point in time, did you ask him, "So what do you think?" Answered by Trooper Ryan Casey, "I did." Did he then respond with the universal hand and arm signal of shooing away as in a letting them go motion? Answered by Trooper Ryan Casey, "He did that motion, yes." So since in court I was doing this, but on the transcript you can't see me doing this. So I had to explain the universal hand and arm signal of shooing away, so that way you know in your mind what he did, which is documented on his own body cam footage that he did that, which at the time I didn't know about. He told me to sit tight. I was seized. I couldn't leave. He launched his investigation according to his own words, and you'll see that later. And then he said, and then you responded with the question, "Yeah?" Answered by Trooper Ryan Casey. I said that, yes. Questioned by me. And then he responded again with the shooing motion, and that I made sounds. I forgot what sounds I made. And he went like that, make sound. As in letting them go motion. And I went, because that's what he did. Answer, I don't know what he was saying by him shooing away. I just questioned by me. So you don't understand what this means. Is that what you're saying? The shooing motion, you don't know what that means. Answered by Trooper Ryan Casey. Yeah, but shooing away could mean numerous things. I mean numerous things like, then my question. So, have you ever told someone to get away from you and kind of made a limp wrist and put it forward in a way? Put it forward as in away from you. Have you ever done that? What did you mean by that? I probably have at some point, yeah. Question by me. What did you mean by that? Answered by Trooper Casey, to get away from me. So so at first he said, I don't know what he meant by that. Then when I asked him, have you ever done this? He said, yes. And what did you mean by that? He meant, get away from me. So he knows what it means, so he lied under oath. Isn't that perjury? So he swore to tell the whole truth and nothing but the truth, said he doesn't know what something means, and then answered it and revealed that he knew exactly what it meant. Okay. Page 50. Question, did I threaten you at any point in time? You did not. You did not deliberately.
I want to make sure I get
You did not deliberately threaten me at any time. Did I point anything at you or any other officers at any point in time? No. Did I attempt to flee at any point in time? Not while I was on the scene. No. When you said you observed a van pulled over in the breakdown lane, is that correct? Or you said you observed the van pulled over in the breakdown lane, is that correct? Yes. Did you see anybody outside the van or outside the vehicle at that time? When I decided to stop? No. Question. Yes. Answer. No. You didn't see anyone outside the vehicle? No. So when you pulled up behind us, there was no one out on the highway already armed. No.
They did try to spin it that way the whole time.
Mr. Abdullah Bey, that's me. Let the record reflect that during the 58A hearing, the prosecutor alleged that we were already out on the highway armed, which is why Trooper Casey then they objected. So they lied. The prosecutor lied and the media lied, and you believed it. Because they were saying, oh, these guys were just armed on the highway, so the police got behind them and shut the highway down.
No, then they, in their paperwork, tried to claim that you guys shut the highway down.
That's my point. That's my point, right? So this is question page 52. Did my behavior indicate any criminal activity? You were holding a rifle, a long weapon, on Route 95, so I'd say yes. Okay, let's do this. Let's do this. Actually, no. So he's saying, I asked him, did my behavior indicate any criminal activity? He said, I was holding, this is what he said. You were holding a long weapon on Route 95, so I'd say yes. So he's saying that holding a weapon is a crime. Which would mean that is his probable cause or reasonable suspicion, right? By just using logic. Okay. This is at, I don't know if you want to show them this. This is riseinthemoors.org. Wait till my computer loads. Go to Res Judicata, click on Second Amendment. Wait till it pops up.
A lot of new information on the website, guys. Free, a plethora of information that you may want to catch up on.
I'll post the stuff that we already went over as far as the Bruin, the Massachusetts Code of Appeals saying that since there is no individual right to keep and bear arms, it's not unconstitutional to license it. But then now that the Supreme Court said it's always been an individual right, that would mean it's unconstitutional to license it according to the appellate courts of Massachusetts. All right, so this is from the Commonwealth of Massachusetts, that carrying a gun is not a crime. That under the Fourth Amendment, the mere possession of a gun is not sufficient to give rise to reasonable suspicion that the defendant was illegally carrying that gun. Now, oh, but that's on your website. Okay, so copy and paste. Copy and paste the decision, the reference. Oh, because Jamal, you made it up. It's on your website. Okay. So why is it that when you Google search it, it's a real case from Massachusetts, and then you just click on it from 2016, right? Then you go back to my website, you copy the text to see if I changed anything. You Control C for copy. You go back to the case from caselaw.findlaw.com, a third-party website. You press Control F to find. You paste what you just copied, and you search it. Make sure it's the right case. 423-266. We'll do so. Go back up a little bit. Notice how I'm not changing anything. It's not popping up. You tried it from. All right, so I had to click on a different one. This is the same. It's the same thing. I don't know why it didn't pop up on here, but it's the same case. Alvarado, Commonwealth versus Alvarado, right? Just so you see what I did. All I did was scroll down because it wasn't popping up on here for some reason. That's not my fault. I scrolled down. I did Control V for paste. It popped up right here. Under the Fourth Amendment, the mere possession of a handgun was not sufficient to give rise to a reasonable suspicion that the defendant was illegally carrying that gun. Which means what? When I asked Trooper Ryan Casey under oath, did my behavior indicate any criminal activity, and said you were holding a long weapon on Route 95, I'd say yes. Well, according to the Massachusetts Court of Essex County, the mere possession of a firearm does not give rise to a reasonable suspicion under the Fourth Amendment. Which means what? Our Fourth Amendment right to due process was what? Violated. Right? So then I said, and you're familiar with Massachusetts law, correct? Answer, I am familiar with Massachusetts laws. So you are aware that in Commonwealth versus Lindsay, specified that the mere possession of a firearm does not indicate criminal activity. It also specifies that carrying a firearm may be lawful in certain necessitated circumstances, and then they objected. Why don't they want their own law from their own state on the record? Because during a motion to suppress hearing, you have what's called an evidentiary hearing, right? Because only the fact finders are supposed to see evidence. But in this specific case, to suppress certain evidence that's going to be entered into the record, you have an evidentiary hearing to see if that evidence was, to determine the moment of the seizure, which you'll see later, seized us within the first 3 minutes of the stop, to see if, any due process was violated. And from the jump, we see due process was violated, right? But anyway, just to give you a little bit about that. This is on page 54. Can you tell me what a sovereign citizen is? His answer, this is Trooper Ryan Casey under oath. Generally speaking, it's a group of people that seem not to go against U.S. laws, that feel that they don't need to follow U.S. laws. At any point in time did I specify that I feel like I didn't need to follow U.S. laws? Yeah, I would say so, because when Sergeant McDevitt said, what if I say you are in violation of the laws, and you just kept saying you would need to have probable cause? Isn't that what the
law says?
Hold on, we'll get to that. And then he said, what if I have probable cause? And then you objected to that. So I would say that's you feeling that you don't need to follow the law. So let's see. What was that's Arabic. You would need probable cause. What is probable cause? This is just Google. Definition: probable cause is a requirement found in the Fourth Amendment that must usually be met before police make an arrest, conduct a search, or receive a warrant. law.cornell.edu.com. .edu, not .com. So, Cornell, the entire University of Cornell is a sovereign citizen, according to Trooper Ryan Casey, under oath, on the record, in court, in front of a judge, on the public record. So everyone that called Jamal's a sovereign citizen, Jamal's a terrorist, these rights wars people are crazy, you can see that this police officer is saying, if you think that I need probable cause to arrest you, you're anti-government. And you don't think that's dangerous. Okay. That's other stuff. That's about anatomy. Don't ask. Page 60. So at several points in time in the video, you said, I'm just trying to figure out what's going on. Is that an investigation? I was trying to figure out what was going on. What was with the rifles? I mean, is that an investigation? I would say that's an investigation. According to Miranda rights law, a suspect must be read his rights if police want to ask him any questions and use those answers as evidence at a criminal trial. And then, according to the video footage that Quinn gave Lamont for some reason and made it public, which is a violation of my right, because Lamont made it public, in Trooper Casey's own body cam footage, the whole world seen he never read us our Miranda rights. When he said, oh no, under oath, he was investigating us. Which means what? The police were asking questions and then using the answers as evidence at a criminal trial, which the prosecutor, Graham Van Epps, submitted that he's going to use that as evidence at trial. What does that mean? That means our Miranda rights were violated. What is Miranda based off of? The Fourth Amendment, which means what? Our Fourth Amendment right to due process was violated. In the same body cam footage that was played in open court with Vice News present recording, Sergeant Matthew McDevitt called the stop team before he even said anything to us. Which, a few minutes later, then he said, I believe you're in violation of the law. After the fact. So you called the stop team.
You believe or you know?
Hold on. You called the stop team before you even had any information whether we violated the laws or not. Which means what? That's called a de facto arrest. Let's look it up.
You should look at it in the book.
No, because they're going to say, well, Black's Law Dictionary that's old. De facto arrest. A detention becomes a de facto arrest if its scope or intrusiveness were beyond that which is associated with investigative detentions, and 2, unnecessary under the circumstances. So, there was no knowledge that we violated any laws. Watch the video. You'll see Sergeant McDevitt shows up before he even talks to me, which I didn't know at the time. I thought, this could be settled peacefully because we're not doing anything. Right? But you'll see later, Trooper Ryan Casey said he was prolonging. That's a de facto arrest. You were drawing it out so you can get, and he said it, he was drawing it out so more officers could show up so they can arrest us. But he didn't know that we violated any laws at that time. So why would you call the stop team if you're not sure that we violated any rights or any laws? Excuse me. That's a de facto arrest. You detained us. You called the stop team. Those are the SWAT guys. It's the state police. Because remember, this is Massachusetts State Troopers. State police SWAT team. You called them before you knew that we violated any laws. Then, right, so I asked him if we were on an investigation. Then I said, are you aware that you would need reasonable suspicion to start an investigation? Van Epp said he objected to that. Because obviously the Constitution doesn't matter. Even though, so that means law.cornell.edu needs to update their information because the Constitution clearly doesn't matter. There was I can't remember where it's at, where he said that he was prolonging. Oh, I know where it is. It's at the beginning, when he was talking to Van Epps after he was sworn in. So on page 44, that's where my cross-examination starts. The beginning is the prosecutor, so Trooper Casey is sworn in on page 8. We go over this whole thing. He said it was community caretaking, which anyone can just Google search and find case law, which is also provided on the website, that community caretaking is completely separate from the ascertaining of evidence for criminal statutes or to prove that you violated any crime or committed any crimes. Also, you'll see in the video footage where Trooper Ryan Casey, before I was ever placed under arrest, asked me to write down my name. So when they're charging me with furnishing a false name after arrest, I gave him my name before I was arrested. The requirement in the statute is to furnish the name after you were arrested. I wrote it down on his thing and then handed it to him before I was arrested. So how am I being charged with giving a false name after I'm arrested if I gave you my name before I was arrested? Look. Question by Van Epps. All right, Trooper Casey, when you were speaking to the defendant on the side of the road, did there come a time where he introduced himself to you and gave you a name? He gave me the name Jamal. I wasn't arrested at that time. So, How am I being charged with furnishing a false name after arrest if I gave you my name before I was arrested? But they always overcharge so that way they can scare people, and then they'll drop certain things that they know they can't prove in the first place. But this is just common tactics that they do to everybody, because most people take deals. And you'll see from different third-party sources that over 90% of cases end up in plea deals because of coercive measures by the Commonwealth or by the prosecutor. This is page 31. Question this is by Van Epp. This is Van Epp speaking, the prosecutor. Okay, you were focused on doing as you were talking to the group and gathering information. I was trying to gather information from everyone, and I was essentially stalling until we get, more people there to logistically take these people into custody while also gathering information. So you're gathering information, which means you're investigating us, which means you don't know that we committed a crime, but you're stalling so that way you can arrest us. But you don't know if we committed a crime or not, because you're investigating. So you admitted that you were investigating us because you're gathering information, right? You're asking us questions to use later at trial during criminal proceedings, which is unconstitutional. And then you're waiting till more officers arrive before you even knew we committed any crimes. Let's look this up. Oh, de facto arrest. Where it's intrusive, beyond that which is associated with investigative detentions. Why? You don't even know what's happening. And you're stalling. What is stalling? What's another word for stalling?
Holding up.
Prolonging. Show this, please. In Rodriguez versus the United States, the United States Supreme Court held that absent reasonable suspicion, which the Supreme Judicial Court of Massachusetts already said mere possession of a firearm alone does not give rise to reasonable suspicion. So the fact that you've seen us with what you believe were firearms is not sufficient to give rise to a reasonable suspicion or launch an investigation. So the United States Supreme Court said, absent reasonable suspicion, which he was absent reasonable suspicion, unnecessarily prolonging a traffic stop can constitute an unreasonable search and seizure. And with that, again, trial is set for May 22nd, 2023.
We could use
There's a chance that it will be
support.
pushed back, but we don't know for sure. So as of right now, at this moment, May 5th, 2023 at 2:37 p.m., it's set for May 22nd, 2023. Courtroom 530 at 200 Trade Center, Woburn, Massachusetts. Notice how it's called a trade center. What is trade? Trafficking. Who goes there? People. Human trafficking.
It will more than likely start around 9 a.m. So day one is usually jury selection. But, Moors, we need as much support as possible. Be there if you can. The first date, the second date. What else do you want to let them know?
I feel like I've said everything.
Okay.
Like I said before, the actions that they're charging me with is conduct protected by the Second Amendment. And according to the United States Supreme Court, everything that they did violated my rights as a Moorish American, my rights as a human being. And if they want to claim that I'm a U.S. citizen, well, then they violated my rights as a U.S. citizen. Whether you care or not, that's up to you. I'm putting my trust in Allah. However Allah decides to decide this, I'm cool with that. But I know what I need to do is fight for my rights because I believe in that. That's the reason why I joined the military, because I believed in constitutional rights. And then when Prophet Noble Drew Ali said enforce the Constitution, it just made sense. Because these are rights that protect everybody. In fact, when we talk about slavery, there were slaves prior to the Emancipation Proclamation, prior to 1865, that used the Declaration of Independence that said all men are created equal as legal arguments to free themselves, and it worked. So this is stuff that's already documented. Look it up. I found this while I was in jail. In Massachusetts, a slave woman used the Declaration of Independence to free herself and say slavery was illegal, and they let her free. So when Prophet Noble Drew Ali said, when the Constitution of 1775 declared all men free and equal, and there's since then there has never been a change to the constitutional government, there's no need for the 14th and 15th Amendment for the salvation of my people and citizens. That's the absolute truth. So when my prophet says enforce the Constitution, I listen. Whatever you do, if you want to fold, if you want to call your brother an agent, if you want to call your brother names and oh he's guilty and oh I hope he's gold, whatever you do is on you. You're gonna have to answer for whatever you did. I'm gonna have to answer for whatever I did. I'm gonna have to answer for my actions and inactions and my words. You're gonna have to answer for your words, your actions, and your inactions. And if you're willing to let your fellow Moorish Americans sit back and suffer and you say and do nothing, that's up to you. And you'll be questioned on the day of judgment by your God, whoever your God is, whether you believe in God or not. It's gonna happen. And don't think that this can't happen to you. Because it happens to our brothers and sisters every day. All the time. And if you ever put yourself in a position to actually help people, you'll constantly get DMs of our people being injured by these people violating their constitutional rights, whether they're Europeans or Moors who work for the European courts. So whether you decide to abandon me or not, whether you decide to abandon my family or not, whether you decide to abandon your fellow Moorish Americans or doing their best to stand tried and true on the things that we've been yapping about for years, that's up to you. My faith is with Allah alone. Whatever the outcome is, Allah is the greatest no matter what. And I know within my heart, I never folded on myself, on my wife, on my daughter, on my mother, on my father, on my future child that's about to come, on any of my relatives, on anything that I claim to believe in. I never folded on any of that. I stood 10 toes to the best of my abilities. If I have to rot in prison because of that, I'll rot in prison as a man knowing that that's what I did. If you want to be a coward, I can't answer for that.
Islam is